The year is 1865. The Civil War is over and the Union is victorious, but now the work truly begins. With victory came the immense task of rebuilding and reintegrating the war-torn South. For many in the North, though, Reconstruction had a higher purpose, finally abolishing the institution of slavery and elevating the freedmen to equality. Unfortunately for them, the great emancipator, President Abraham Lincoln, would not be the one to oversee this project, as shortly after the war's end, an assassin's bullet would send Lincoln to his grave and Vice President Andrew Johnson to the White House. Johnson did not share the idealistic view of Reconstruction, instead setting low requirements for the Southern states to quickly rejoin the Union and allowing them to enact black codes that basically reinstituted slavery after it was forbidden by the 13th Amendment. His leniency encouraged widespread violence against African Americans in the South to prevent them from exercising their rights as citizens, sparking outrage in the North. In the 1866 midterm elections, Northern voters overwhelmingly backed the Republican Party, which promised a more aggressive prosecution of Reconstruction. Now, with firm control of Congress, Republicans passed the 14th Amendment, aimed at protecting the rights of the freedmen, and the Reconstruction Acts, which imposed martial law in the South and required Southern states to ratify the 14th Amendment as a prerequisite to readmission to the Union. Johnson tried to obstruct all of Congress's Reconstruction efforts, but was repeatedly overridden. Eventually, Congress got so fed up with him that the House impeached him in 1868, though the Senate narrowly voted against removing him from office. Regardless, the Republicans still regained control of the presidency later that year in the election of 1868, and the new president, Ulysses Grant, was a strong supporter of a firm Reconstruction. In his first term, Grant pushed for the ratification of the 15th Amendment, which protected the right to vote from being denied based on race. He also signed the Enforcement Act into law, criminalizing conspiracies to prevent someone from exercising their constitutional rights. Grant made aggressive use of this law against the many white supremacist organizations terrorizing the South, most notably the KKK, founded by ex-Confederate veterans shortly after the Civil War ended. However, some Republicans began growing disenchanted with Reconstruction, believing it had already gone far enough, and defected from their party, allying with the Democrats in the 1872 elections. Though their presidential candidate lost to Grant in a landslide, their defection fractured the North's support for Reconstruction. As Grant's second term began, violence was still pervasive in the South. White supremacist groups continued their violent campaign to redeem Southern states by seizing power from Republican officials and subjugating the freedmen. Soon enough, this insurgency would reach its crux in Louisiana. The state was no stranger to violence in the Reconstruction era. In 1866, a white mob killed several dozen freedmen and Republicans in the New Orleans Massacre, and 2 years later, white militias killed around 1,000 more in the lead-up to the 1868 election to ensure the Democrats carried the state. In 1872, though, it seemed like the election might actually be fairly peaceful. For governor, the Republicans nominated William Pitt Kellogg, one of the state's senators. Democrats, meanwhile, fused with some dissident Republicans and nominated a guy named John McHenry. The election itself was actually fairly peaceful, but things went sideways immediately after when both sides declared victory. Kellogg and McHenry each had themselves inaugurated, and 2 legislatures, one Republican and one fusionist, claimed to be legitimate. A federal judge ruled that Kellogg and the Republican legislature were the rightful officeholders, and Kellogg eventually gained control of New Orleans, then the state capital, after heading off an attempted fusionist coup. But in rural Louisiana, chaos reigned. Elections for local offices across the state feature similar splits as the gubernatorial race, with both the Republican and fusionist candidates declaring victory. One such dispute occurred in the city of Colfax. The area's whites refused to accept the Republicans' victory and formed a militia to place the Democrats in power. In response, the Republican sheriff authorized the formation of a militia to defend the local Republican officials from being overthrown. This militia was pretty much entirely composed of African Americans, who made up most of the parish's Republicans and were hoping to protect themselves from white terrorism, which the area had a history of. They and their families took refuge in the Colfax courthouse and prepared for the attack they knew was coming. However, their militia was poorly organized and poorly trained, since none of the freedmen had any fighting experience, and they barely had any weapons, ammo, or gunpowder. The white militia, on the other hand, was twice as large, made up of many ex-Confederate veterans, and far better equipped. When the attack finally came on Easter Sunday, 1873, the results were pretty lopsided. Despite a valiant effort, the black militia was forced to retreat into the courthouse, which the white militia then set on fire. As the black militiamen tried to surrender or flee the burning building, they were gunned down. The survivors were rounded up and that night were executed at the direction of a man named William Cruikshank. He's important, so remember him for later. While the exact death toll is unknown, estimates generally place it between 62 and 81. Some even put it over 100. Nearly all of the casualties were black. The Colfax Massacre was the most vicious crime in all of Reconstruction, and for U.S. Attorney James Beckwith, it could not be allowed to go unpunished. After an investigation, Beckwith secured indictments against 97 of the massacre's perpetrators for violating the Enforcement Act by conspiring to oppress the constitutional rights of the black militiamen. By attacking the black militia gathered in the courthouse, they deprived them of the freedom of assembly and right to keep and bear arms. By killing them over a legal dispute over election results, they deprived them of the right to due process. By using violence to punish them for voting for the Republicans and deter them from voting again, they deprived them of the right to vote. They were also charged with violating the victims' constitutional rights in general, targeting them because they were black. You may be wondering why Beckwith chose to prosecute the defendants under the Enforcement Act rather than just charging them with murder, but under America's federal system, the power to prosecute most crimes, including murder, belongs to the states. In 1873, basically everyone agreed that the federal government had no constitutional authority to prosecute someone for murder. Plus, there was precedent for using the Enforcement Act to prosecute a crime like this. When the Klan attacked a meeting of Alabama Republicans in 1870, prosecutors had convicted the Klansmen for oppressing the Republicans' freedoms of speech and assembly. At the time, the rights in the Bill of Rights only secured freedoms from being violated by the federal government, so the defendants claimed the government could not prosecute them, private citizens, for violating other people's rights. Judge William Wood disagreed, though, citing the recently ratified 14th Amendment, which prevents states from denying their citizens the privileges or immunities of U.S. citizenship. Wood ruled that the rights in the Bill of Rights were some of the privileges or immunities of U.S. citizenship, which the amendment's authors had specifically said was the case, so state governments had to protect them. Alabama's government, however, had done nothing to protect its citizens' rights from being violated by groups like the Klan. According to Wood, this inaction amounted to a denial of rights, meaning the federal government could intervene to protect the rights of its citizens. In the unrelated slaughterhouse cases, the Supreme Court had narrowed the scope of the privileges or immunities of U.S. citizenship to only those rights that had been created after the ratification of the Constitution. Nonetheless, Beckwith was confident the indictments were constitutional, and he chose to seek the death penalty for the defendants. First, though, he had to round them up, which quickly proved difficult. Many fled into the bayous of Louisiana, and most of the state's whites, who saw them as heroes, were happy to help them evade capture. Eventually, Beckwith managed to track down 9 of them, including one of the worst offenders, William Cruikshank, and their trial opened at the federal courthouse in New Orleans in February of 1874. Beckwith's prosecution strategy had 3 parts. First, prove the black militia had legally gathered in the Colfax courthouse under the authority of the sheriff. Then, prove that a massacre had indeed happened, and then finally prove the defendants had perpetrated that massacre. To this end, Beckwith summoned dozens of witnesses, including several survivors of the massacre. Levi Nelson and Baptiste Elzy, who'd been shot during the mass execution of prisoners but survived, and Benjamin Brim, who sustained but miraculously survived multiple gunshot wounds, now took to the stand against their would-be killers. With others, they told the story of the massacre, highlighting how they'd been unarmed prisoners during the slaughter, how many of the victims had been shot in the back trying to flee, and how they'd barely survived. They also testified that the defendants had used racial slurs during the massacre, and that the white militia had attacked to punish them for voting in 1872. The defense, meanwhile, used a very sophisticated legal strategy. They bribed or intimidated witnesses to get them to lie under oath. If they wouldn't lie, they scared them away from testifying at all. With this strategy, the defense invented a story of a black mob terrorizing the good people of Colfax and the white citizenry banding together to protect themselves. The 2 groups fought a fair, pitched battle, and when the white militia carried out a giant white flag to signal they wanted to negotiate, they were shot at. In a righteous fury, they finally defeated the black militia. Also, most of the defendants hadn't even been in Colfax on Easter anyway. The defense notably didn't question the constitutionality of the Enforcement Act, an implicit admission that they thought the prosecution was constitutional, or that they thought doing so was a waste of time, since the judge presiding over the case was William Wood, and they already knew where he stood on the issue. Regardless, after both sides delivered their closing statements, the jury was sent to deliberate. Beckwith had labored non-stop building the best case possible to send the defendants to the gallows, and pleaded with the jury to provide justice for a horrific crime. His witnesses had risked their lives, first at the Colfax courthouse, and again showing up at the New Orleans courthouse. All of this couldn't have been for nothing. The jury deliberated for a day, then 2, then 3, and then finally it announced a verdict. One of the defendants was acquitted, and for the other 8, among them William Cruikshank, they just couldn't agree on a decision. The white jurors steadfastly refused to convict. With a hung jury, Judge Wood declared a mistrial. If Beckwith wanted justice, he'd have to try all over again. The retrial of the remaining 8 defendants opened in May of 1874. For the most part, everything was pretty much the same as the first time around. Both sides laid out their arguments in much the same ways they had before, though now with several more witnesses who'd been found since the first trial. However, there was one major difference. Back then, Supreme Court justices periodically traveled around certain parts of the country to preside over lower courts, a practice known as riding circuit. It just so happened that one Justice Joseph Bradley was riding circuit in the South when he arrived in New Orleans for the start of the retrial. Bradley wasn't exactly a huge fan of Reconstruction, and seeing an opportunity, the defense moved to question the Enforcement Act's constitutionality. They pointed out that the Bill of Rights had only ever prevented the federal government from violating certain rights. The government had no power to protect those rights from being violated by private citizens, and the 14th Amendment hadn't changed that. It only empowered the government to stop states from denying people their rights, but the state of Louisiana hadn't been the one who attacked the black militia. Essentially, the defense was claiming that if a state did nothing to protect people's rights, that did not amount to a denial of those rights, so there was no grounds for federal intervention, meaning the case had to be dismissed. Bradley didn't immediately rule on this motion so he could have more time to consider it, but allowed the trial to continue in the meantime. Then, he left New Orleans to keep riding circuit, leaving Judge Wood to preside over the rest of the trial on his own. Like I said before, the case was otherwise basically the same. The jury was sent out to deliberate on June 9th and returned with a verdict the next day. 5 of the defendants were acquitted, but the remaining 3, including William Cruikshank, were actually found guilty. They were convicted under the lesser charges in the indictment, so they wouldn't face the death penalty, but they would nonetheless go to prison for conspiracy to deprive the black militiamen of their rights. Given the depravity of the crime and the number of people involved in it, this was an incredibly small victory. 3 people would be jailed for a massacre committed by 300. Still, this was a far better outcome than outright acquittal for all 8 defendants, and it represented a major personal triumph for Beckwith. Against all odds, he'd shown there was a chance for justice to prevail in the South. But then Justice Bradley came back to New Orleans, having decided to uphold the defense's motion and dismiss the case. Wood disagreed, and with the 2 judges presiding over the case divided on the issue, the dispute would have to be resolved by the Supreme Court. Not long after Bradley's decision, an emboldened white supremacist paramilitary organization called the White League attacked New Orleans to overthrow the state government. In the Battle of Liberty Place, the predominantly black New Orleans police force and state militia, who were led, oddly enough, by ex-Confederate General James Longstreet, attempted to defend the city but were forced to surrender. Governor Kellogg was swiftly reinstalled after Grant sent in the army, but across the South, white Democrats were violently toppling Republican governments. Up north, the Panic of 1873 had sent the economy into recession, dampening public support for Reconstruction, an expensive project infamous for being rife with corruption. This backlash manifested in the 1874 midterms, where the Democrats made massive gains. Reconstruction was dying, and now before the Supreme Court was the case with the potential to kill it altogether. Reconstruction wasn't dead just yet, though. On March 1, 1875, Grant signed the Civil Rights Act of 1875, banning racial discrimination in public facilities. The future of Reconstruction depended on laws like these, and the future of these laws depended on the Supreme Court's decision. Not only was justice for the victims of Colfax at stake, but so was the fate of freedom in America. On March 31st, the Supreme Court began hearing arguments in one of the most important cases that would ever come before it, United States v. Cruikshank. Told you that guy was important. Representing the government was Attorney General George Williams, who hadn't been very supportive of Beckwith's prosecution or of prosecuting white terrorism in the South in general, but was committed to winning this case all the same. Williams decided to only defend the part of the indictment charging the defendants with conspiracy to oppress the black militia's right to vote and their constitutional rights in general. The decision to abandon the charges related to freedom of assembly, right to keep and bear arms, and right to due process was part of a pragmatic strategy by Williams to focus on what he thought were the strongest parts of the case. Why did he do this? Remember the slaughterhouse cases I mentioned earlier? In the unrelated slaughterhouse cases, the Supreme Court had narrowed the scope of the privileges or immunities of U.S. citizenship to only those rights that had been created after the ratification of the Constitution. Williams was worried the Supreme Court thought that the rights in the Bill of Rights predated the Constitution. After all, the Bill of Rights restricts the government from violating those freedoms, seemingly implying that they exist independently of the government. He focused on the right to vote because that didn't come from the Bill of Rights, but the 15th Amendment. Williams also argued Congress had the inherent authority to regulate the election of its members. As for the general suppression of rights charges, Williams believed Congress had the power to do this under the 14th Amendment as part of its responsibility to protect the privileges and immunities of American citizenship. Many people, including Williams himself, had been involved in passing both the 14th Amendment and the Enforcement Act. Obviously, they must have intended for the amendment to give Congress the authority to pass the act. Why would they pass a law that violated the amendment they just wrote? The Supreme Court announced its decision on March 27, 1876. Like Williams expected, the court found that the rights in the Bill of Rights had existed before the Constitution. The Bill of Rights only barred the federal government from violating these rights, so there's nothing it could do to protect them from being violated by private citizens. This responsibility had always and continued to belong exclusively to the states. The 14th Amendment had to change this because the rights in the Bill of Rights weren't part of the privileges and immunities of U.S. citizenship since they predated the Constitution. On top of that, the federal government still had no power to protect those privileges or immunities from being violated by private actors anyway. They could only stop states from passing laws that denied them. With that clarified, the court moved on to demolish Williams's arguments, pragmatic and limited as they were. The 15th Amendment did not create a right to vote, only a right to vote free from racial discrimination. While it may be suspected that race was a motive, the indictments hadn't explicitly alleged a purely racial motive, so they were unconstitutional. This was basically impossible, since the defendants could easily claim they had a political motive. Congress also didn't have the inherent power to regulate the election of its members because the right to vote, guess what, isn't a privilege or immunity of American citizenship. And if you're starting to think the whole privileges or immunities thing sounds pretty useless, you'd be right. Finally, the charges related to the suppression of rights in general were too vague since they didn't specify any single right and were thus unconstitutional. The court's ruling did not strike down the Enforcement Act, but it did narrow the ground for prosecutions under it so much that it was almost worthless. Not once did the court's decision even mention the reality that dozens of people were butchered. Now, the butchers would get to walk free like nothing even happened. In the months that followed, violence in the South began ramping up in the lead up to the 1876 elections that November. Through violence, fraud, and intimidation, Democratic presidential candidate Samuel Tilden easily won every southern state that federal troops had withdrawn from. However, the Army had maintained a presence in Florida, South Carolina, and Louisiana, enabling Republican leaders in these states to throw out the fraud-tainted results and declare their candidate, Rutherford Hayes, victorious. Democrats contested this and declared Tilden the winner. Also, there was an unrelated dispute over the results in Oregon. Because of all these disputed states, neither Tilden nor Hayes had a majority of votes in the Electoral College. Congress couldn't decide on a winner because the House was run by Democrats and the Senate by Republicans, leaving the nation paralyzed. When Grant's term ended, who would be president? To answer this question, Congress created an electoral commission made up of 5 representatives, 5 senators, and 5 justices. 8 members of the commission were Republicans, but only 7 were Democrats. In a series of 8-7 decisions, all of the contested states were awarded to Hayes, giving him the presidency. Democrats were outraged and threatened to refuse to accept these results, but they were willing to concede the White House on one condition. In the Compromise of 1877, Hayes was allowed to take office, and shortly thereafter, all federal troops were withdrawn from the South. Reconstruction, which had begun with so much promise, so much hope of building a union built on freedom and equality, was over. It had died a failure. With federal oversight gone, Southern Democrats could finally complete the redemption of the South. The remaining Republican officials were forced to concede power, beginning a period of de facto one-party rule that lasted for close to a century. The freedmen would become free in name only. Systematically stripped of their rights, they'd be relegated to second-class citizens. As part of the Compromise of 1877, Louisiana Democrats had demanded that Beckwith be removed from his post as U.S. Attorney for the state, and Hayes obliged. Beckwith would stay in Louisiana until his death in 1912, watching as the project he staked his career on was undone. In 1880, the indictments against the remaining 88 defendants Beckwith hadn't been able to find were formally dropped. 3 years after that, the Supreme Court struck down the Civil Rights Act of 1875 in the civil rights cases. This ruling built on the decision in Cruikshank, further limiting the government's ability to defend its citizens' rights from being violated by private actors. In 1890, Republicans made a final effort to pass legislation that would protect voting rights in the South, but they were unsuccessful by just a single vote. Not long after, Southern states passed a wave of laws establishing racial segregation. The Supreme Court upheld these laws in Plessy v. Ferguson under a twisted reading of the 14th Amendment. United States v. Cruikshank played an integral role in killing off Reconstruction and ushering in the Jim Crow era. Bradley's decision to reverse the defendants' convictions in the retrial directly led to a massive resurgence in white supremacist violence in the South. It also caused the number of Enforcement Act prosecutions to fall off a cliff as prosecutors waited to see how the Supreme Court would rule, further emboldening white violence. The court's decision in Cruikshank only validated this violence and effectively stripped the executive and legislative branches of their ability to protect civil rights. The 14th Amendment's Privileges or Immunities Clause, meant to broadly protect the rights of American citizens, including those in the Bill of Rights, was basically erased from the Constitution. As the 1876 elections approached, violence in the South exploded unchecked. Tired of the seemingly endless conflict in the South, Northerners grew increasingly disillusioned with Reconstruction. When Democrats demanded the Republicans withdraw the Army from the South as the price of victory, they complied. The federal government had essentially just been coerced by white terrorists into abandoning Reconstruction, and the Supreme Court had barred them from doing anything about it. In the following decades, the federal government could only stand by helplessly as the rights of its citizens were made completely worthless. There wasn't much demand for another round of federal intervention in the South anyway, not after Reconstruction's failure. In 2010, the Supreme Court heard McDonald v. Chicago, a case concerning whether the Privileges or Immunities Clause protected the right to keep and bear arms from state governments. The court was specifically asked to overturn the precedent from the Cruikshank decision that the rights in the Bill of Rights were not covered by this clause. In its ruling, the court seemed to acknowledge that its interpretation of the clause in the slaughterhouse cases in Cruikshank was far too narrow and that these cases were probably wrongly decided. However, they declined to overturn them, finding that doing so was unnecessary for the case at hand. Today, Cruikshank is still the law of the land, and given its immense legal and historical significance, it's strange how forgotten it's become. Reconstruction in general has been forgotten because of its ultimate failure. If it is remembered, it's remembered as a corrupt failure. However, nowadays some historians have taken to calling the period the Second Founding, and I think the name is appropriate. There were many successes during Reconstruction. Abolishing slavery was no small thing, and the 14th and 15th Amendments completely transformed the nation, even if their full potential wasn't realized yet. There were many failures too, though, and as a whole, it's true that Reconstruction failed to bring about the freer and more equal society envisioned at the end of the Civil War. That shouldn't take away from the fact that it was still a heroic effort carried out by presidents, prosecutors, ordinary people, and everyone in between to build a better society. Reconstruction didn't fail because it was bad, it failed because it was so far ahead of its time. When that time came, ideas that had already been imagined only needed implementation. Work that had already begun only needed completion. Today, that work continues. Personally, I hope the courts finally overturn Cruikshank and deliver some small degree of justice to the victims of the Colfax Massacre. At the very least, I hope that people talk about United States v. Cruikshank, the landmark court case nobody remembers.